One of the excessive force cases that we've been following just settled, and you may or may not be surprised at the settlement amount. This is the one in Kentucky where the man was arrested inside his parents' home and was beaten, not terribly, but still beaten, by two Kentucky state troopers. Then the dad goes on to get his cell phone and he starts filming, or attempting to. The troopers then took the phone and deleted the footage. Well, as sometimes happens, the parents had interior surveillance cameras that the cops did not know about. My buddy Chris Wiest filed a lawsuit against them. He puts them under oath at their depositions, and then he asks them about it. Both troopers denied even striking the guy.
Once you had him on the ground, did you strike or hit him with a closed fist at all?
No, sir.
Or any part of your body?
No, sir.
Okay.
Unfortunately for them, they had been caught on camera and Chris had the footage. I got the opportunity to talk with Chris this weekend about a few of his cases, including this one. Again, this is breaking news. This case just settled. I actually saw it in the news first, and then I texted Chris and said, hey, congrats on the settlement. I'll let him tell you about it, along with some of the other interesting details about this case and about suing the police in general. But here's what happened. On April 9th of 2020, Kentucky State Troopers James Cameron Wright, Thomas Zartorsky, and a third trooper, Kevin Dreisbach, went to the Hornbach's home in Shepherdsville, Kentucky, to arrest 29-year-old Alex Hornbach for a missed appearance in Jefferson District Court. Hornbach's mother and father met the cops at the door, and they led Wright and Zartorsky to the basement of their home where their son was, while Dreisbach covered the rear of the house. Zartorsky and Wright testified in their January of 2021 depositions that they had a relatively calm interaction with Hornbach, despite taking him to the floor, and that they did not use any other force or strike him. The Hornbach's lawyer, Chris Wiest, later released home security video contradicting the troopers' statements, i.e. showing that they lied. The video showed Wright grabbing Hornbach around the neck and slinging him to the floor, though Hornbach was not visibly resisting. The video also showed Zartorsky striking Hornbach 4 times on the legs with his flashlight. Wright hit Hornbach twice in the back with his right forearm and appeared to have his left knee on Hornbach's neck, pushing his face into the floor. Hornbach did not suffer any serious injuries. Only one of these state troopers would continue to be a state trooper after this. But let's hear from Chris. Give me a recap of this Zartorsky case that you've been litigating for so long.
Well, we litigated that up to, it was like a week or two before trial, and I wanted to try the case. My co-counsel wanted to try the case. It's been reported now in the news. They put, $135,000 on the table, and the clients wanted to take it. And,
I know we talked about this before. Could you just briefly explain again in the Zartorsky case, the video, what happened?
Well, Dad had the basement video. The other side did not require production of what we had in our files prior to taking positions under oath. And I got early depositions of these troopers, and they lied about it, not knowing that we had video of the incident because they thought that they had deleted it off of Dad's phone. So they thought they were clear, and they thought they had successfully covered it up, and turned out they didn't. So clients make settlement decisions, and the Hornbach family did, and it got settled for what it got settled for. So I thought it would have been a really fun case to try from my perspective, but clients make settlement decisions, not lawyers. So,
well, it's got to be a fun case to try where the defendant has been charged with perjury. Right?
Yes. And I thought it was, there were some other aspects of that. There were 2 troopers who were part and parcel with all of it, and they were scapegoating the guy that got charged with perjury. And I felt like the other 2 had just as much culpability in it and, weren't being charged with perjury. And the guy that was being charged with perjury was being scapegoated because they were all kind of in cahoots. They tried to exclude prior incidents of use of force from these same 3. There was sort of a pattern in the month prior, and the judge was going to let that in. So there was some in limine practice on that. We got in limine rulings. Mom's claims got tossed. She was unlawfully detained outside. We were going to take that up on appeal. They were going to let in parts of the client's criminal record, which, gets into the he had it coming defense, which they were going to try and use. So, all of them, it's a typical use of force case. I have yet to do a use of force case in which, to some degree, the client, through their conduct, did not in some way have some involvement with it, right? Because if you just roll over generally and you're just, there's absolutely no pushback, they'll come in, they might rough you up a little bit, but it doesn't usually there's always something, either words or something else, that precipitates these folks to like lose their cool and engage in the excessive use of force, in my experience. And so to some degree, he had a coming defense. It was going to be a play in Hornback. I have yet to do a use of force case where there's not some attempt by the defense to argue he had it coming.
Why did the judge allow some of your clients' criminal history to come before the jury? Is that because the cops were aware of it at the time the incident occurred?
Yeah, that was it. The cops said they were aware of it, and that factored into their apprehension about the client. Was what they said.
And why is that? Did it have to do with potential violence against police officers?
No, what was interesting? I mean, she tossed. So he had like some drug stuff. She tossed all that. She said that's not coming in. He had a prior fleeing and evading, not a conviction, but a charge that he denied. And she was going to let that in. And I'm like, how in the world are you going to do that? I mean, but I think the conviction for fleeing and evading would have been, that would have been probably valid, but she was going to let a charge in that was dismissed. And I'm like, Judge.
So how many defendants were there in this case?
Three.
And so the one who could be seen in the video hitting the guy with the flashlight, that's the one who got charged with perjury and fired.
Right. That's Tom Zortorsky. Yep.
And he was fired while your case was pending before trial.
Right.
So did he get thrown completely under the bus as far as insurance coverage goes?
So, that's interesting. There is no insurance that any of these guys have. The state, it's whether or not the state's going to indemnify them. There's an indemnity statute on whether or not, the state judgment fund is going to be used to satisfy those claims. And in this case, they were always, that was why I think we got the case settled for what it settled for, because the defense was always sort of rattling the saber of no indemnity, no indemnity, no indemnity. Good luck collecting your judgment, which, to which I said, that's fine. These guys make a paycheck. I'll take a quarter out at a time, because you could take a quarter of their paycheck out every pay period. That's always an issue sometimes with suing the state police versus a municipal police, because there's usually not private insurance coverage. It's always just a state indemnity fund. And, they raised that if they did here.
So after that guy was fired, did they provide his defense lawyer?
They did provide a defense. They were saying they were not going to provide indemnity, actual sort of payout of the judgment or attorney fees and costs and that kind of stuff.
So in the media report that I saw, it said that the case settled for $130,000, and then $5,000 of that was to be paid by Sartorsky.
No, it was $135,000. I thought it was $130,000 plus $5,000 out of his pocket.
Kentucky State Police will pay $130,000 of the $135,000 settlement, and the remaining $5,000 to be paid by Thomas Zartorsky.
Right.
Why $5,000 from him? How'd that come up?
Well, we demanded that he come out of pocket for it, because I said I'm going to hit him with punitives. He's going to come out of pocket for it. When I hit him with punitives, something's coming out of his pocket. So they said, we're not putting any more state money in other than $130,000. And I said, well, I'm going to send a message, and the message is $5,000 out of his own pocket.
And what about, I know there were a couple other videos, right, of Sartorsky hitting some other people?
Yes.
Was any of that going to be allowed to go to the jury?
Well, we could use it. Yes. She said we could get those prior incidents in. Yes.
What was the legal basis for that?
Pattern and practice, lack of mistake. We argued all of the exceptions to the prior, where you can't say he did it before he did it again. But so we argued, they argued it should come out under 404A and B. We said we're not going to use it in terms of acts of conformity. We're going to use it under 404B2 to prove motive, opportunity, intent, knowledge, absence of mistake, and lack of accident, and which are all Rule 404B. And then we said all of this goes to the heart of the punitive damages case, namely that these guys were motivated by an evil motive or intent, or at a minimum acted in reckless or callous indifference of the protected rights. And so, she said we got to get it in. So,
well, that's a big win, because I know they always fight me hard on that, trying to keep out any of that, any of those prior allegations.
So I think that the timing mattered a lot. The fact that this was done in the month prior, and at the time he was under a use of force investigation for those prior incidents at the time they did this, and at the time they deleted the footage. And what I argued in part was, look, this is why they ordered the footage deleted, because he was already under investigation. So we have to be able to talk about it. And she agreed.
Now the other two defendants, are they still employed at the Kentucky State Police?
They
Or
are.
were they disciplined at all? Do you know?
Well, I don't believe so.
And presumably they didn't have to pay any portion of that settlement.
Correct.
How close did you guys come up to trial?
We were about a week away. I had booked. I mean, we had expert travel arrangements. We had booked hotels. We were prepared. We were prepared. I mean, we were prepared to try it. I had my opening statement ready. We had our cross-examinations ready. We had our witness outlines ready. We were ready to try the case.
And did they just wait to the very end to really come to the table?
I think so they started to put real money on the table in about a month out. And we're like, it's not enough. It's not going to get it done. And there was some back and forth where they went back to go get more authority, and that didn't get it done. And then when they realized we were really serious and we were going to try it, then then we got over six figures. And then it was just a matter of, seeing where, how close we were going to get. And I would say it was probably a couple weeks out. I thought it was probably going to settle. I start prepping about a month out. Like once I get my eliminate rulings, I know what's coming in and what's not coming in. That's when I start my prep for trial.
I think one of the most confusing things about these types of Section 1983 excessive force cases is how are they valued? Negotiating back and forth where you have the insurance adjusters on the other side that they're only interested in are there any medical bills and things like that. And obviously we're looking at it from a different point of view. I mean, how do you argue for, valuation of a case like this where a guy has been beaten, but he doesn't have any severe injuries?
So, I don't overvalue that. If there's not, I mean, we had photos of bruising here, and I put a number on that in, the $10,000 to $15,000 range. And then I thought, well, it's probably going to be another $15,000 to $25,000 in punitive exposure. I thought was probably where we would end up on the punitive exposure. But what drives these settlements, particularly at the 11th hour, is the fact that they know that we had lodestar time for the people that are watching this channel. That's the attorney fee time, and there's attorney fee shifting where they have to pay the other side's attorney fees. And we've got my co-counsel and I know you do in West Virginia, we have fairly well-established rates that, because we do enough of this work where courts are awarding fees with some regularity. So we know what our hourly rate is. We know what courts have approved for that hourly rate. It's a matter of the number of hours we had in the case. And I will tell you, our attorney fee time was going to be substantially higher than what we settled this case for. And I felt like we were going to get a verdict on the underlying liability, and the attorney fee award itself was going to exceed it. Now, from the client's perspective, it goes to trial and we get an attorney fee award. We have the option in our fee agreement of keeping the attorney fee award. They keep what the jury gives them. And so they were going to not make as much money on the case. And, they kind of made some money off of our attorney fee time. And I think that was a huge driver in this case. And, that sometimes, unfortunately, is on some of these where you've got like a soft tissue injury and you don't have hospital bills. And I think the other side fully appreciated the attorney fee exposure. I had a case in 2019. Client, gave a state trooper a one-finger salute, and you can imagine what entailed after that, which was a wrongful arrest, a wrongful stop, wrongful charge. Ended up getting tossed in state court at a preliminary hearing of all things. Allegedly assaulting the officer because he was trying to record the interaction by pulling the phone away. It was just, kind of a bad deal. The jury gave the client $800. And the defense attorneys were like high-fiving each other on the way out. And I'm like, well, that's a bold move, Cotton. Wait till you see the fee award. And, it was almost like $100,000 in fees that the judge awarded and, attorney fees and costs. Now, the client didn't get that. We got that. And, I think the state police had been down this road with us before, and I think they knew, I don't think they were particularly afraid of the client's damages. I think they were afraid of getting hit with the six-figure attorney fee award. That would have been every bit of that.
Now, was there a claim made related to them deleting the video?
I mean, we argue, we argue the unlawful seizure of Dad's phone and the unlawful deletion of the video, which was a Fourth Amendment seizure we claimed, and the judge agreed that could go to the jury. We also asked for a spoliation instruction, and that was, I think likely to be instructed to the jury too. The whole, you could assume, because they deleted the evidence would have been highly unfavorable to them. You should make that assumption. I'm instructing you to do that because they spoliated evidence. And so we asked for that instruction as well.
Did any of the other defendant officers get caught lying under oath in this case?
Zartorsky obviously, I think, was the most blatant. Cameron Wright said that he didn't use any force on Hornback, and obviously, you saw that strike to the back of the head or neck. So that was not truthful. He was not charged for it. But obviously his testimony was inconsistent with the video. So, and nothing's happened to him as a consequence of that.
Did the feds ever show any interest, can you say, in investigating these guys?
I would not be allowed to comment about things that I might understand are still active federal investigations, and just let me leave it at that.
So there you have it. Accountability has been achieved. It wasn't perfect, and it never is. But it's the remedy available to us, and it was actually pretty successful in this case. The best thing that you can do is share this footage and this news far and wide so that as many people as possible see it and hear about it. That is what the government fears the most. As always, thanks for watching. It's always a fantastic opportunity for all of us to hear Chris explain what he's been up to in these cases. And again, if you search past videos on this channel, you'll see some of our prior conversations, including several videos about this one, I believe. Now, Chris practices both in Kentucky and Ohio, so if you're in need of a civil rights lawyer in those states, that's who I would try first. I'll put his contact information in the description. I get a steady stream of calls from people all over the country searching for a civil rights lawyer. As I said in the last video, I only handle cases in West Virginia. If you watch my channel, you know that I have my hands really busy here in West Virginia. I am working on compiling a referral database for all 50 states. So if you're a civil rights lawyer in a different state or you know of one, please let me know and I'll include you or them on the list. And if you have a West Virginia matter that you actually want to speak to me about and I can handle for you, I do have a limited number of consultations available each week that I try to do. Sometimes I can't. So if you're interested in that, I do have an actual office with people answering the phones who can set you up. Please be polite to them or you will not get through. If you enjoy this type of content, reviewing police interactions, discussing constitutional law, please subscribe and keep the channel growing almost to 250,000, and I really appreciate it. Remember, freedom is scary. Deal with it. I'll see you next time.